Hello and welcome to Legally Speaking with me, Tarun Nangia. Today is the part 2 of our series on the Prevention of Money Laundering Act, where we specifically raise the topic of what was, in a sense, adjudicated by the court, that in PMLA cases, the grounds of arrest have to be supplied by the Enforcement Directorate to the person who's being arrested. So it's become mandatory that the accused have a right to get the grounds of arrest on the basis of which the ED has decided to arrest them. It helps them defend themselves in court. This was laid down in the Basant Bansal and Pankaj Bansal case, of course, popularly known as the M3M case, the real estate company to which they belong. And I have a team of lawyers who appeared for Basant Bansal and Pankaj Bansal and got them relief in the Supreme Court. I want to welcome Advocate Neha Nagpal, Advocate Manak Bhatt. They are part of NM Law Chambers. Appreciate that you could make time to join us, and thank you for your time.
Thanks for having us, Tarun.
So at the outset, we will take two quick opening comments on this case, the legal grounds, and then we move on to the specific questions on PMLA. Neha, if you could start with your opening comment on this case in about 1 minute.
Sure. Thank you, Tarun, for that. So what the M3M case, more particularly the judgment in the case of Pankaj Bansal has done, has sort of laid down a framework which deals with the role of the Enforcement Directorate, the role of the magistrate, the vital power that is given to the Enforcement Directorate under Section 19 of the Act, its significance on liberty, and also sort of lays down the manner in which arbitrariness can be controlled, what may come across as arbitrary in as much as that grounds of arrest have to be communicated in writing was never a direction earlier from any court. So it's also sort of laid down the framework, the sort of the protocol that has to be followed prior to an arrest. And of course, one very important observation that simply or non-cooperation cannot be held as a ground for arrest. There has to be some material on record that justifies and gives you reasons to arrest. Those reasons to arrest have to be written in writing. They have to be communicated in writing to the person being arrested. The judgment also notes that you can't orally just communicate that to the grounds of arrest to the person being arrested, because they've literally gone on to criminology and psychology to say that obviously the mental condition of a person being told that I'm going to be arrested or you're going to be arrested is not where they will recall or the grounds of arrest and recall the material. So and that they've tied that in with obviously constitutional frame guidelines of liberty, that and therefore and justified that the Prevention of Money Laundering Act has twin conditions to bail, and those twin conditions while have been upheld, but they've been upheld because the burden and the threshold that you have to meet for arrest is slightly higher than in a normal case, which has to be justified within the realm of Section 19. So I think that really summarizes the way I look at the judgment.
Okay, thank you for that opening comment. So Justice Bopanna and Justice Sanjay Kumar have, in a sense, given, in a sense, a lot of relief to many accused who, first, have been arrested, many who will be arrested in these cases. Also a lot of relief to lawyers who now know what to argue on. I think to Manak Bhatt, partner at NM Law Chambers, for his opening comment.
Thanks. So I'll echo Neha's sentiment on this, but I'll call this a landmark judgment on 3 counts. And I'll keep the opening comment restricted to these 3. It's landmark on these 3 very, very important factors. Number 1, on the fact that the notion that one who is arrested by the ED only has recourse to bail is now a foregone fact, is a misnomer, because the judgment strikes to the core of mandatory and strict compliance to the procedural safeguards within the PMLA. So if there is a situation where the ED has not followed the law laid down or the law as is prescribed under the PMLA as interpreted time and again by the Supreme Court, your recourse is not that you wait till a charge sheet is, a complaint is filed, or for that matter, you wait and file for a bail. You have the remedy of going before the magistrate, going before the High Court, challenging your very arrest. Number two, and this I feel is also a very critical part of the judgment, is that a lot of lawyers and obviously a lot of companies facing ED investigations thought that with Vijay Madan Lal Chaudhary coming in and upholding the vires of the PMLA, doors on a lot of other issues were shut because every provision of the act was held to be intra vires. It was held to be constitutional. What the judgment very interestingly does is it leaves Vijay Madan Lal open for interpretation by saying, look, the purpose of Vijay Madan Lal was to say there are enough and more safeguards, accountability standards, enough transparency mechanisms inbuilt within the PMLA and the way the sections are drafted to ensure that the rights of the accused are counterbalanced to that of the ED. This judgment takes this a step further and says, while the judgment may not have dealt with what those safeguards are, at every stage, rights of the accused will definitely need to be taken into account. And that's where this is a step further on interpreting Vijay Madan Lal to say, when section 19 was upheld and court said, look, you will be, because the words used under section 19 are informed, and the court said, yes, you have to be informed about the grounds of arrest. Judgment goes a step further and says, inform means inform in letter and spirit. The third very important aspect of this judgment is accountability. When provisions of criminal law are framed and are strictly interpreted to ensure that the rights of the accused are taken care of, I think this judgment is one of the finest examples of how the court has read within the ambit of PMLA, I would say, the overlapping rights under Article 20 and 22 of the Constitution to say, look, a statute at no point in time can be read to defeat the very purpose of Article 20 and 23, or 20 and 22. So, for example, grounds of arrest is one. Second, evasiveness can never be a ground for arrest is now, with respect to a premier investigating agency, said in so many words. So I think on these three counts, this definitely is a great move by the Supreme Court.
Thank you. Malak Bhatt calls this a landmark order in that sense, where the Supreme Court has, in a sense, looked at the rights of the accused. I take this to Neha Nagpal. Ma'am, two things I would like to know from you. Point number one, in the Vijay Madan Lal Chaudhary judgment, which is now being challenged in the form of a review by many of the parties, supply of the enforcement case information report is the thing in question, that the accused are not given a copy of that. Do the accused need a copy of the ECIR at all if they have the grounds of arrest? Has that question been solved once and for all with this order of the judges of the Supreme Court?
So it's very interesting that you raised that point, Tarun, because that has actually been dealt with in this judgment in a not very detailed manner, I have to say, but yes, it's been touched upon. While writing their judgment, the Supreme Court observed that in Vijay Madan Lal Chaudhary, Section 19 and Section 45 were upheld. And one of the reasons for upholding the twin conditions of bail was also that because under Section 19, reasons of arrest have to be given, which have to be done in a detailed manner. Therefore, the constitutional mandate under Article 22 will remain satisfied if you give detailed reasons for arrest. And therefore, providing the copy of the ECIR was held to be not absolutely necessary. So I think to answer your question, yes, once again, Supreme Court has actually come forward and tried to curtail the arbitrariness or the ad hoc manner of arrest, try to curtail simply arresting by saying that someone was being evasive or non-responsive. And it's not always somebody is not being non-responsive. This is a company which is still owned by the promoters. But what happens to those cases where the promoters are now ex-promoters in light of insolvency proceedings? They genuinely don't have documents. They don't have access to data which was way back relevant, balance sheets or other board minutes which go back to 2016, 2017. So they're not being evasive there. Memory can fail you. You don't have access to documents. And sometimes you are actually saying the truth, but which may not look like the truth. So that doesn't necessarily mean being evasive. So the rethumping that you have to give grounds of arrest kind of deals with not just curtailing the arbitrariness, but also dealing with the issue of not giving someone the ECIR, because grounds for arrest are actually slightly above and more than the ECIR. ECIR, colloquially speaking, is just the impetus to start the investigation, like the way the FIR does. Grounds for arrest are actually when you've investigated what is the material that you found.
But very interestingly, what you mean to say before I go to Mr. Malak Bhatt is that ECIR could be filed and there could be no arrest for months. But if the agency thinks that the grounds that they have now found out through investigation merit an arrest, is when the arrest happens.
Correct.
Mr. Malak Bhatt, I want to know this from you, that if in many of these cases, evidence is always documented. Now, if this evidence is documented in the form of bank statements, etc., means that it is not something that can be tampered with. How does the agency arrive, A, whether to arrest somebody, B, in this case now, when the grounds of arrest have to be given, and if the grounds of arresting are not convincing enough for the court, though it may be convincing for the agency, does it mean that we'll see more bails in ED cases henceforth?
Interestingly, not just bails, but you may see that the courts may refuse remand in most cases, and I'll tell you why. See, unlike normal police cases where CRPC applies, Section 41, which contains the power of the police to arrest, uses the word suspicion, that the police should have a reasonable suspicion to believe that the person has committed the offense. Vijay Mandalal Chaudhary started this at a point by saying Section 19 is valid for two reasons. One, the power to arrest has been given to the highest officers. It's with the director or the assistant director, who in the hierarchy of the ED are the top level officials, which will ensure accountability. And number two, the wordings used within Section 19 are that he should have a reason to believe, which reason has to be recorded in writing, that the person is guilty of offense. And guilt is a very high level of standard which the ED is required to meet. Now, where does the grounds of arrest issue really come in? Because when I'm given the grounds of arrest and I'm, let's say, given the physical copy as is now mandated under this judgment, if I can, during the time of my remand, show that the grounds do not reach the level of guilt or are somewhere hanging between, the documentary proof available today does not satisfy the requirements of Section 19, the judgment today gives, I would say, not just teeth, but a lot of ammo to the magistrate sitting as a authority under Section 19 to refuse remand. And that's where the court has really called upon the magistrate to say, look, you read Section 19(1), not just in isolation, but with Section 19(2) and 19(3), because these are where the safeguards for the accused are otherwise built in, to say the material will be forwarded to the judge, will be forwarded to the adjudicating authority. And that person is not just a rubber stamp, but will have to really apply his mind to see if the requirements, which are otherwise at a very high threshold, have been met by the ED or not. So to answer your question, let's say there are bank statements or there are documents which are otherwise in the nature of publicly available records from institutions or from other financial institutions, etc. And that's the basis on which the authority really comes to a conclusion that, yes, this person is otherwise involved in money laundering. But if the material on its own standing cannot reach the presumption of guilt, then you at that stage of remand also will be able to oppose it, and the court will be duty bound now in light of the judgment to actually apply its mind and see whether a remand is made out or not.
Okay.
Read this fact coupled along with now the requirements of Section 167(2), because that is one provision which otherwise is all encompassing. 167(2) is a right which the accused has, which the magistrate really has to apply his mind at, with it, be it any case. Since the language of 19 is very similar to the language in other statutes like the NDPS Act, like the Customs Act, and the judgment at no point says that this is applicable only to the ED, this accountability today, which the Supreme Court has built, is now going to be made applicable, or at least argued by lawyers across various other statutes, which I think is going to bring in, as you said, a lot of duty and responsibility on the magistrate, not to just be a tick box on the remand and say, yes, allegations are grave and therefore remand. Because now the judge is going to distinguish between a remand order and just an order of custody to say, yes, it's a remand order, allegations are grave, so I will not grant you, I will not allow you to oppose the remand, let the remand continue. Now he'll have to really apply his mind and see if the requirements of that provision are made.
Point well taken. I'll take this to
I just
Neha
add something
now.
there when Malak said that NDPS and customs, but also SFIO, because they're very similar, identical provisions in terms of SFIO also. So the threshold is higher across the bar.
Okay, point well taken. Do the accused person has a right? Does he have a right? This question is to Neha Nagpal, that he says that I don't know, wouldn't like to comment, can't remember. Do these qualify for answers when one goes for questioning by the Enforcement Directorate, or answers have to be mandatorily given?
Well, look, so we're not dealing with a case especially in cases of money laundering, or for that matter, SFIO, or for that matter, bank fraud cases, which are current. When I say current, it's not a road accident or a murder case, which has happened in the last 48 to 24 hours where investigation is happening. Most of these transactions date back to 10 years ago, if not longer. So it's only human to not be sure, not be clear, or sometimes not be very accurate about things. I mean, how many of us remember where we were last week having lunch? I mean, you know what I mean? So any transaction done in the course of thousands of transactions, if it's being isolated out to sort of, if you're called upon to impromptu answer it, anybody is in that position will not be sure. The pressure that you are being investigated by an agency, you're anyway confused, curious, anxious. So I think one can't assume and presume that somebody is being evasive, especially when you have to juggle your memory. Therefore, the threshold is much higher to find material and reasons to believe. Also, what I think is that a lot of that material does end up coming from the accused persons themselves, because it's all documented and they're all pertain to either their personal accounts or their companies or their kith and kin.
So where we are getting as the agency has a right to summon documents to be presented before the agency will investigate. It is not necessary that during the course of questions, the accused should have to be able to answer everything. Otherwise, he could be arrested for being non-evasive.
Obviously not. That's humanly impossible, because see, a lot of times also you can have a COO sitting there or a CEO sitting there, but it's really the accountant who's done the transaction. The CEO or the promoter may not be able to explain the transaction with that much accuracy or fluency of accounts the way an accountant can. So merely because the agency is not getting the answer they want to the precision they want does not mean somebody is being evasive.
That's a very important answer, ma'am, because a lot of promoters would want to know this. Because when you're arrested and questions are asked, there are dilemmas of,
In fact, I'll go a step further. See, in the context of ED, one has to realize that you are dealing with an agency which today, in light of the judgment, is not police. And what you define under the act, what they are conducting is an inquiry. Coupled with that, you have section 50 of the act, which says that the statements that the ED takes are admissible on oath. See, unlike a 161 statement given to the police, you can always come out and say this was never my statement because you don't sign it. A 50 statement is admissible on oath, is binding on you. So a promoter going in and say, forget, I don't know, I will not answer this question because it implicates me into an offense which you're otherwise investigating. I think basis now this judgment is a very valid answer, because what the court today has done, it has only given voice to Article 20 subclause 3, which says you cannot be compelled to be a witness against yourself. if ED expects me to say that, yes, I've committed the offense of money laundering and only that will amount to cooperation, then every person is non-cooperative. Because no person is going to go and say, I've committed the offense. So
Which
what
also the judgment observes, that you can't expect somebody to be giving evidence against themselves.
So today, I think in fact, the fourth landmark point of this judgment, it says, I will not go and say I have committed the offense. And if I don't say that, it does not give you a ground to arrest me.
Oh, that's a good point. Where you're saying that I have this right not to answer in that sense. But this is what you're effectively saying.
Yeah.
That's right.
Okay, where are we heading because of this order? In a sense, there are many other cases where people have been arrested, though they don't have an ECIR or grounds of arrest. Where are we headed because of the order in the case of Pankaj Bansal and his M3M case? Over to Neha Nagpal.
So, I've always been a firm believer of the fact that whatever it is, our judiciary is very active. It has always come forward to protect liberty. Once again, I think the Supreme Court, more particularly the judiciary of this country, has come forward in protection of liberty. It is truly a landmark judgment, which is path-breaking, because this was very many times as lawyers, we do face this problem, not just in ED and SFIO cases or NDPS, but also in cases where they're mere IPC offenses, where there's only the CRPC that is applicable, that the grounds for arrest or the reasons for arrest or the suspicion, more in an IPC case, is never really properly put forward, or a person is being arrested merely because on the ground that he's not cooperating. Now, not cooperating is very evasive. You could have joint investigation 5 times and the IO could still say you're not cooperating because you're not giving the answers he wants. So I think in that sense, it's once again streamlining things. It's once again, covering tracks that were left sort of slightly hazy and laying down a framework, which is very, very important.
Point well taken. I have one more question, which I'll ask again the both of you, over to Malak, Manish, but first. If the grounds of arrest are not convincing and the court holds them to be so, do the rigors of twin condition apply? If they apply, then bail becomes difficult, A. But if they don't apply, then the court on what grounds shall release the accused?
So simply put, at the section 19 threshold, if at the time of seeking remand, if the threshold of section 19 is not made out at all, and the magistrate finds that the ED at any point of time has not complied with the strict requirements of its A, procedural safeguards, and B, subjective satisfaction of reaching the requirements, the threshold requirements of 19, it can actually ask the person to be released there and there itself.
That doesn't amount to bail.
That in fact it's a step before bail, because you will seek bail only once you're in custody of the court. You don't even need to seek bail because the court has never taken into custody, declaring your custody itself to be illegal. So interestingly, if you see the last part of this order, lot of reporting around this judgment happened to say that the M3M promoters got bail. It's not bail. It's in fact much better than bail. It says the custody from the time the persons were arrested, the custody was illegal from the word go. Release the persons forthwith. It does not say grant bail, because then you'll have to be subject to terms and conditions. Today, there is no condition on them. They are not under, because in bail also what technically happens is you are in the custody of the court. You are just released from the actual physical custody of you being in judicial custody. A release order is that you are in no custody of either the investigating agency or the court, and which I think is a very, very important step that this judgment takes. And I'll take this further as to what to answer your question as to what happens next, like where are we headed. I think we are headed towards a lot of accountability. We are seeing Vijay Madan Lal being expanded, being interpreted to see that at any point of time, merely because the act in its most rigorous form has been upheld, does not do away with the critical fundamental rights of accused. So today it's illegal arrest. Tomorrow it may be with attachment, because most of the time we also see that the attachment orders are mechanically passed. The confirmations are verbatim copies of the provisional attachment orders. The courts have in the past come down on this. This very similar issue on reasons to believe also came up before the Delhi High Court with respect to attachments, and the court took a progressive stand saying that no, the person whose properties are attached has a definitive right to know what are the reasons to believe which has led you to believe that the asset that is being attached to the proceed of crime. Okay, welcome step. So I think, and this also is a recent development. So I think time as we pass, I think we are seeing a lot of marrying in of rigorous provisions, because one has to also understand that the PMLA was brought in for curbing large scale money laundering, which was happening in India for a very long time. And as part, if you see the judgment also, part of our obligations to our FATF are very stringent, very strict for being part of that protocol. So, to meet that, but at the same time safeguard that the investigations don't go around in a haphazard manner, and the rights of people who are facing the investigation don't go subservient. I think at every point of time, the court is keeping its eyes open and taking every step, which is, I think, in the most forward direction.
Okay. One final comment. We're almost out of time. Neha Nagpal from NM Law Chambers.
So I think it is definitely a very progressive step. I completely agree with Malak that it is time for enhanced accountability, curtailing arbitrariness, curtailing, pressurizing on the context. If you don't answer this, or if you don't answer this way, there is an apprehension of arrest, or you will be arrested. So I think that is a very, very welcome step. It's also puts a lot of emphasis on the role of a magistrate before whom a remand is moved. The magistrate is not a post office. The magistrate has to apply their mind. The magistrate has to weigh the material that is produced. And also, I think what the judgment has done, it has balanced the twin condition requirement under Section 45 vis-a-vis the high threshold of giving reasons to believe and material supporting the arrest. So you just can't meet twin conditions by forsaking this. And it's also sort of brought in that accountability that if you forsake the Section 19 requirement, the arrest can and will be held. That's definitely sort of a course correction, I say. And I'm hoping that as we move forward, this sort of high threshold will be sustained and maintained.
Okay. Point well taken. So now let us take one quick final comment on the other areas, which is the review petition that was filed, which relates to twin conditions. Do you think that will be the final thing, and that a lot of...
Yeah, so I think if you look at the timing of the judgment also, it's come at a time where ED's accountability is now being looked at a much higher level, because the judgment itself says you're a premier investigating agency. See this in the light of the fact that the next very week, on 18th October, there is a 3-judge bench which is going to sit and start looking at the PMLA batch. Justice Kaul is heading the bench. He's indicated orally in court that he's looking at fixing up 4 or 5 issues which arise from the Vijay Madan Lal judgment. I think this judgment will definitely have a bearing on the manner in which the court now looks at those provisions. If not, if not looked at negatively within the framework of the legislation, I think the court will really have to bring in balancing acts and will have to bring in parameters on which these actions can be taken. See, one also has to understand that the facts in this case were slightly grave, but as Neha said, balance within the framework of Section 19, the powers to arrest, also means that the court at every point of time cannot go into whether the subjective satisfaction of the ED was right or not. So it's not like an appellate forum where you say, okay, fine, out of 5 grounds, 4 grounds are right, 1 ground is wrong that you have raised to release me. That can't be, because ultimately it's an investigating body doing its work, and courts time and again have said that we will not interfere in the investigating agency's body. But at the same time, the judgment comes at a time where the review is up at stake. The review may then consider that, look, if this is what has happened with respect to powers under 19, now let us look at or at least frame some guidelines on which powers under section 5 for attachment or 8 for confirmation or 17 for seizures are used, so that on all fronts we are able to counterbalance the rights between the accused and the investigating agency, if not toned down. So I think it's definitely a factor which will be argued and heavily considered by the court.
Thank you so much for answering all these very important questions. Also, this landmark order from the Supreme Court in the M3M case, which both of you were a part of, representing the Bansals, comes a huge relief, and it will have an impact on as many as 50-55 cases, is what we are being told. Of
I
course,
think
we look
much more.
forward.
I really think much more. 55 maybe just ED, but if you really look at it, it'll have an impact on a lot of cases across the board.
Lot of cases across the board. Looking forward to invite you again when we speak more on the review petition in Vijay Madan Lal Chaudhary, where section 45, also the issue of attachment position, many more issues which require clarification, more information by promoters will in a sense then we will discuss. But thank you so much for joining us today on this show of Legally Speaking, where we got to know on the M3M judgment and the importance of this order. Thank you so very much.
Thank you.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.